Okay, welcome to Priority Message, the podcast from the Fire and Rescue Services Association. And believe it or not, this is Series 4 and the first episode of Series 4. And my first guest is a very, very special guest who's been on the podcast before. It is Claire Johnson, Senior Pension Advisor from the LGA, the Local Government Association. Hello, Claire. Welcome back.
Hi, Tristan. Thank you for having me back. I appreciate it.
No, obviously you've come on to talk about pensions.
I have.
And I can tell you that in terms of our YouTube channel, when you come on before, it's the most popular video we've ever uploaded.
Wow.
So no pressure.
Yeah, no pressure at all.
No pressure. But it's great to have you on. Obviously, pensions is a massive topic, very popular, particularly at the moment with regards to the second options exercise.
That's right.
So there are many, many people out there who have got lots and lots of questions. I know you are not going to be able to answer all of them, but it would be really helpful if you can provide an update from when you last come on to the present day, where we are, how we got there, and hopefully where we're going to be going in the future. So do you want to start off with the government consultation that took place a while ago?
Yes, so I think that's a really good place to start. So you'll be aware, or you may not be aware, it depends how close you are to pensions, but back in 2025 now, in fact, earlier than that, back in December 2024, there was a consultation launched by the Home Office, which was the government department that had the responsibility for pensions. That has since now moved from the Home Office to another government department, MHCLG. And the consultation ran for a number of weeks and closed in February 2025. However, there was quite a big passage of time before we actually got a response to that consultation. Most of that was down to the department's move from Home Office to MHCLG that has delayed things for the government department. But just before Christmas, the consultation was published. It was published on the 4th of December. And the consultation, so just a bit of a recap for everybody, in terms of what was proposed in the consultation, there was some significant amendments, firstly in respect of deceased firefighters. So these are individuals who would have been in scope for the Matthews remedy. However, due to the unfortunate circumstance that they're no longer with us, their Matthews election under the current regulations no longer stands. So they're not able to make an election because they're no longer here, and the current regulations do not allow any of their beneficiaries to make an election on their behalf. The consultation focused on this group of people and suggested that actually this wasn't a fair treatment for them, given the fact that, this is the second Matthews exercise that we're on now. You could argue that the amendments are really Matthews 3, but I've been told by government that I'm not allowed to call it that. I've got to call it Matthews 2B. But ultimately, we are onto the
It's like a film sequel.
It really is. It really is. And it gets worse every time we go along. We just think, can we get to the end of this, please? For the sake of, the people that I support, which are the scheme managers back at the FRAs, but also for the members as well. This has dragged on now since 2014 when we first had the first set of regulations that came out. So back to this group of members then. So as I've already mentioned, these are individuals that are no longer with us and are no longer able to make an election. So the consultation focused on the fairness of this, and the consultation looked at providing provisions in the amendments to allow beneficiaries or an estate of an individual to be able to recoup this money on the member's behalf. So we know that was consulted on. We know that the consultation response was quite supportive of having a provision in there for these. And we know that from the 1st of April, amendments will come in to allow individuals who would have benefited from Matthews if they weren't deceased to have their Matthews payments either paid to a beneficiary or, in the absence of beneficiaries, paid to their estate. Now, in terms of the intricacies of that, I'm not going to go into too much detail on that, Tristan, because what we are waiting for is the draft regulations to be shared with us. So what I don't want to do in this call is to say something that actually I haven't been able to see in the draft regulation. So we know that that's currently with lawyers. So at the moment, it's just a very high level. We know that something is coming. And in addition to that as well, we also know as well, in respect of the survivors of these individuals that have passed away, we also know that there's going to be additional provisions coming for them as well. So it won't just be the firefighter that would be benefiting, it would also be the survivor of the firefighter who will benefit from these amendments as well. On top of that, again, we know that there are going to be some more changes to the existing regulations that are in there at the moment around additional death grants. So for an additional death grant to be payable under the current regulations, part of the eligibility criteria says that an individual must have elected for benefits under Matthews 1, but had since died before making an election under Matthews 2. We do know that the amendments to the additional death grant will allow people who didn't make an election under Matthews 1 to also be in scope as well. So that's good news that has been looked at, and it has been agreed by government that there was a little bit of a flaw there, and it is worthwhile addressing in these amendments.
Okay, if I could just come in there, Claire. So just to bring it down to a simpleton's level like myself, when you talk about the regulations, this is all about legislation, the way legislation has been written, and the fact that because you are dealing with such a high level legal statutory instrument, that the flexibility just isn't there to allow fire and rescue authorities to do what you know that they should be doing, what the legislation was intended to do, and that what is fair. And what will be coming in from what you've said, we haven't seen the draft regs yet, is to make that fairness a more formal document, and to ensure that people can do and access what the original intention was, if I've understood that correctly.
Yeah, it is. I don't know whether it was the original intention of the regulations. I think that this is something that has been flagged to government since the original regs have been published, to say, actually, is it fair that this group of individuals who, through no fault of their own, will not have access to that remedy because they've died before you have, you've got your act together basically and been able to put the remedy out there for people to apply to. So, for example, we know that individuals have taken part in Matthews 1, which was 10 years ago. When it comes to Matthews 2, unfortunately, they've passed away. They would have had a right under Matthews 2, but that right has sadly, because of the way that the regulations are currently worded, that right has sadly died with them. So it's to address that point there, really. It's that fairness point to say, is it right that their option dies with them? We certainly at the LGA didn't think that it was, which is why we've pressed very heavily with government on making these amendments. So we're very supportive of this approach from government.
I think that's another important thing to highlight. You and your team have been so supportive in listening to people like myself, FRSA, other unions, etc., to highlight, because you can have the best intentions with legislation, but it's until you get into the weeds of it that you understand the implications of this, that, and the other, and particularly time aspects. So I just want to put on record the fact that without your support and all the stuff that your team does, we either wouldn't have got to where we are, which I think is a good place currently, or it would have taken a lot longer. And that we are snowed under, particularly at headquarters here, with regards to queries under Matthews 2, stroke 2B. And we know that you are too, because you're obviously getting it from fire and rescue authorities, etc. So I wanted to clarify that that you have been instrumental in your team in ironing out these, what I would call, flaws, and trying to get us into a better place to ensure that the scenarios you've described, because we've had to have those conversations in the past whereby somebody who has sadly passed away, and obviously it's sad enough, but then to tell the survivor, actually, that means that money that you thought you were going to be able to receive, you now can't. That's difficult. So the fact that work has been undertaken to overcome that, I think is really, really positive. It means that we've got a positive message to put out now, and this is part of that. So we're very welcome about what's happening, but also acknowledging that you haven't seen the draft regs yet.
Yes, no, and thank you for that. No, I think that's really appreciative. You're right. There has been a lot of work done behind the scenes with the team at the LGA on this, but also as well, I think it's worthwhile just acknowledging that, government are listening. It's, they do want the right thing for the members here. And yes, it has taken to Matthews 2B to get there for some of them, but they are responsive to this as well. So that's a really good news story for hopefully people that are listening on your podcast.
And I think from what you've said to me before, if the government hadn't listened, and I agree they have been, and their response to the consultation did take a long time, but it was a welcomed response. If that response had been different, potentially, talking about Matthews 1, 2 and 2B, we could have had a Matthews 3. Where there might have been a legal challenge further on down the line and drawn this out even longer than what it currently is.
Exactly, yeah, and that was one of the aims really of the consultation and the amendments. One of the aims was to mitigate any legal challenge that was, potentially circling. And I definitely think, in respect of these deceased members that we've just spoken about, there was a really strong case there. I'm no lawyer, but I can see the unfairness in the current policy, and I think what everybody wants to do is to make sure that public money is spent wisely, and having another legal challenge about this doesn't seem the right thing to do. So government have recognised that, hence the amendments.
No, that's really, really positive, and it's welcomed. And I know you will be issuing information in a timely manner as and when more information is available, and we'll be doing exactly the same thing. Is there anything else within the consultation that you wanted to go through?
Yeah, there's a couple of other pieces as well which will be relevant to your audience. So a couple of other things that are in the consultation. So first of all, there is an extension to conversion options. So I'm trying not to get too technical here, but I'm reminding myself that I am talking about quite a technical subject. So please rein me in at any point that you feel appropriate, Tristan. But as things stand at the moment, individuals, when their case has been processed by a fire and rescue authority, they're grouped into one of the three categories. So you're either a firefighter, a special firefighter, which means that you are an active firefighter. You could then be a special deferred member. So these are people that have either left the organisation or may have opted out of a pension scheme and are no longer actively contributing. Or you could be treated as what we call a special pensioner member. So these are individuals who have attained normal pension age, so they're over the key age, and they can receive their benefits as a pensioner immediately as soon as Matthews has been dealt with. Now, conversion options for individuals who are treated as special deferred members do not currently exist under the current remedy, under the current regulations. So what this means is that individuals can purchase special service up to the point that they have either left or they've chosen to opt out, and any standard service, so some individuals may have joined the standard 2006 scheme, any standard service has to remain standard. It can't be converted into special service. Now, under the amendments, that is going to be removed. They're going to be treating all the groups completely the same, whether you're a special firefighter, special deferred, or special pensioner member. They will all be given the same options in respect of conversion. So what this means to individuals is you may have been given your remedy already. You may have thought that actually Matthews for you is done. You've started to pay your money, or it's all been paid by lump sum. It's been dealt with. But if you are a special pensioner, there is a possibility that your fire and rescue service will be writing back out to you with some alternative options. You don't have to take those options. You might be happy with exactly what you've got. However, you might think, do you know what? This is actually in my best interest. It gives me a higher pension. It means that I can access my pension sooner in some circumstances. There will be a cost to that. It doesn't come for free, so it will be the same terms that was applied before in terms of the cost formula. Interest will also apply to that as well, but it will be a choice that individuals will be able to make once these amendments have come into regulation.
So again, that I think is a welcome move. There's a table, you will know what I'm talking about, because it's a helpful resource. There's a table in terms of the different scenarios that an individual can find themselves in and what they would therefore be able to do. And when we received that and went through that here at headquarters, there was a couple of cases that we had that we looked and we thought, hang on a minute, this individual did what you can term as the right thing. They joined a pension scheme to look after their future, etc. And by doing that, they seem to be in a worse position by not being able to convert to special membership.
Yeah.
And that's the way the regs were, and that information was absolutely correct. But it did, to us, clearly seem unfair. So the fact that that is looking to be rectified to ensure that a wider pool of people are able to have the choice, and it is all about choice, to be able to convert, I think is really, really positive news. And one of the things I wrote down while you were talking that you touched on was that if anybody is listening or watching and you're thinking, well, does that apply to me? What does that mean? We would advise that you go and ask the question of somebody, whether it's your union, whether it's your employer, former employer, etc. But don't do nothing, because you might have the opportunity to increase your pension than you presently do. And we would acknowledge that fire and rescue authorities have been working very, very hard in the background to try and trace people, but it's not a perfect science, and some people do slip through the net. You'll be aware that we did a piece on Radio 4 Moneybox that subsequently went into the Radio Times and went into Saga magazine, that pulled out over 500 people who previously had slipped through the net. So that there are still people out there, we believe, that are walking around quite happy but oblivious to the fact that they potentially can take part in this options exercise. And the other thing, and I know we've spoken about this before, when you have the conversation with these people who are out there, you're talking about free money, depending on your circumstances. And we're always taught there's no such thing as a free lunch, and if it's too good to be true, it probably is. But this is the exception to that rule. And trying to get that message over is very, very, very difficult.
Yeah, and I can imagine that. And I think what I would say to individuals out there is that, I think that a lot of them are looking for advice to be given to them. Now, that's not our role at the LGA. It's not your role either, Tristan, is it, at the FRSA, if I can get my words out. But also as well, the FRAs, the administrators, they're in this position as well where they can't give advice. So we do recommend that, go speak to somebody independent, get their take on this. But you're absolutely right. It's a really good package. And yes, in some circumstances, there are tens of thousands of pounds that's due in backdated contributions and interest, etc. But there is also a significant pension that is at the end of it for people as well. So they do need to go and really consider their options and take that independent advice about what's right for them.
Absolutely. We always use the caveat that we aren't qualified to provide legal advice and that they need to do so. But we always have a conversation with them to suggest that perhaps this is advantageous to them and their family. So with regards to the consultation, are there any other aspects we need to delve into?
Yeah, there's just a couple of two more things, Tristan, if that's okay, that I can just give a little overview of. So again, something else that's currently in place under the current regs, which doesn't sit very well with us at the LGA, is around individuals who have taken that proactive action of joining the 2006 scheme at the point it became available, or at a point after April 2006, and then deciding for whatever reason that actually they don't want to be part of that anymore, and making the decision to opt out of that. Now, what we know through the current regulations at the moment is the period from when you have opted out and beyond, you are not able to buy back under the Matthews remedy. You can only buy the period up to the point that you have opted out. Now, that is completely at odds with the position of somebody who never joined the 2006 scheme, has always remained opted out. They can actually buy back the full period of Matthews, which will take them right up to the 31st of March 2015. So again, to make sure that there's parity, the MHCLG in their consultation have agreed that they will be lifting the restrictions on opt-out cases, so people will be able to buy back those periods of service as well. So that's another really good win for people, to make sure that we've got parity across all those cohorts there.
And I think this goes back to obviously about fairness, but people made decisions based on their circumstances at the time. They didn't have a crystal ball. They didn't know that they were going to have Matthews 1, Matthews 2, Matthews 2B, etc. So this basically seems to wipe the slate clean and say, okay, with all the information that you've got now, what would you like to do? And that seems pragmatic. It seems, more importantly, it seems fair. And it does even it out for everybody.
It does, definitely. Like I've mentioned already, it creates that parity between the different groups of people. At the moment, we don't have that, and that never sits well with myself. So, no, you're absolutely right there.
Fantastic. So again, looking at the consultation and the proposed changes.
So just the final point that I want to mention, which I don't know if it will go down as well as the previous subject matters that we've just been discussing.
It's all been good news so far.
It has all been good news, and this isn't necessarily bad news. So in terms of deadlines, we have been working up to press with the current regulations having a deadline of the 31st of March 2025. Now, we all know that we're now in 2026. That deadline has long gone, a long time ago. Now, for various reasons, some individuals have been able to access their Matthews remedy within that window, some haven't. We at the LGA have been working very closely with those FRAs that have been struggling to be able to allow access to the Matthews remedy within the timescales. We've flagged our concerns to government, explaining that there are things that are beyond the control of the FRA. So, for example, Matthews is complicated, and I'm not just going to sit here and make that statement if it wasn't true. It is extremely complicated. So getting the right level of expertise to come in and to support this exercise has been very difficult for some FRSs. Some FRSs have been really overwhelmed with the volumes of people that have been in scope. We've got one FRS that's got over 1,500 people that are in scope. And I think as well for Matthews 2, what we know with Matthews 2 is that it isn't time limited. We know of some cases that are going back to 1965, and digging out the data for cases that goes back so many decades has proved extremely complex. So when all of those things are all added together, it just provides the perfect storm. So we went to government quite early on to say we've got some concerns here that the 18-month deadline in legislation isn't going to be sufficient. Would you consider extending that? Now, that extension request was not taken lightly, because what we do understand at the LGA is that while ever there is an extension, there is a person at the end of it that's having to wait longer for their money. So it had to be a real balancing act here. And something that was discussed at the time was obviously these amendments that we've already spoken about. So it's agreed by government to consult on bringing in the amendments and allowing an extension to Matthews 2 to run alongside the amendments. So that's where we are. The deadline has now been extended, or it will be extended once the legislation is in. It will be extended. We are expecting it to be extended until the 31st of March 2027. And the reason why that date is key is because all of those amendments that we've just spoken about, those are due to come in from the 1st of April 2026. So fire and rescue authorities will be given a 12-month window to be able to implement that, but they'll also be given the window to implement everything that's already in Matthews 2. It's not just the 2B parts that have got the extension, it's Matthews 2 overall.
So in your professional opinion, and you know better than me where fire and rescue authorities currently are, is that a realistic timetable in which to conclude the exercise?
I would think so, yes.
It feels right to me as well.
It does. I mean, what I would say is that we certainly won't be asking for any further extensions from government. That doesn't feel right from my perspective. I feel that members have waited long enough. What we are doing at the LGA, we've expanded our team quite recently. We've brought a person on board who has got first-hand experience of Matthews 2. She was previously involved at a fire and rescue service. She was in charge of delivering the project. That project for them has gone exceptionally well. So she's going to be leading on this from our side here at the LGA. We understand that fire and rescue services now have a better grasp of what Matthews is. The majority of them have got the right people in there that are able to work on the data, that understand the remedy, that have got a clear plan on how they're going to deliver it. In terms of the amendments, what we have been doing at the LGA is trying to prepare the sector as much as possible for these amendments coming in. So, for example, we host regular coffee mornings with the sector. We hosted one back in October as a little bit of a warm-up to say, we feel like you need to get a good grasp of your data. These are the people that look like they're going to be in scope by the amendments. Go away and look for them now. And we hosted another coffee morning last week after the amendments have come out to say, right, we pre-warned you in October. We're now in January. This is where we are. You go and find these people if you haven't done so already. So we are hoping that fire and rescue services are reacting and are being very proactive with their project planning here.
And as somebody who attends some of those coffee mornings, I can tell you how welcome they are, how productive they are, and by the number of people that attend, because you can see how many people attend, you've clearly got people out there who are performing a job that they want to perform to the best of their ability, to the benefit of everybody. I obviously see the questions that are in the chat, and the questions that are asked of you and the team, and it's clear that they want to get this right, and that they want to ensure that everyone does. Because I know there is perception out there from some people, because we certainly have those conversations where the view is, well, I've waited so long, they're obviously not interested. They are interested. You highlighted one authority that's got 1,500, who are in scope. It's a mammoth task, and of the cases that we touch on here, and the complexities of the calculation and the information that's required, we know it is really, really complicated and difficult, and a small element of information that's incorrect could mean that everything that comes out the other end is incorrect. So it does take time to get these cases done. There are frustrations out there. We feel those frustrations, but you've confirmed that there's going to be extension, and that extension should be enough time to ensure that all those eligible individual cases will be concluded. We definitely have an increase in knowledge and experience coming in, certainly in your team. Cannot speak highly enough of your team that you've got there, because I speak to them probably every week, sometimes more than once a week. So we're very grateful for what you're doing, and the fact that you are there as an advisor to the fire authorities, whether that be informal or formal. You pump out lots of resources. You've got, I think, a fantastic website as well. The coffee mornings are brilliant. And the key message I want to get across to anybody who's watching and listening is that we've got individuals who are trying to deliver on the expectations of the individuals that are out there as fairly and as quickly, but more importantly, as correctly as possible.
Absolutely. And I think, the point that you mentioned earlier, Tristan, the people out there, they really do care. They want to get this right. They want to get it right. So yes, I can probably see that for some people, the perception is, well, they haven't got to me, they don't care about me. I can assure you that they do. The number of queries that we get into our inbox on a daily basis about Matthews, people wanting to get it right, really shows to me the commitment that people have. And just talking about the magnitude of the Matthews remedy, some people that are dialing into this podcast will be familiar with the McLeod Sargent remedy. Yeah, give me 10 Sergeant McLeods over this. Yeah. This is much more complicated. It's much more time consuming. And we know that the wider public sector are really struggling with the McLeod remedy. Gosh, if we were to give them Matthews, I think it would really put some to test.
Yeah, absolutely. It's a mammoth task, and everybody's doing everything they possibly can. And in fairness to the government as well, with regards to the response to the consultation. So it definitely is a positive picture that you've painted, and I think that's a fair reflection of the landscape in terms of the planned amendments to the legislation and the impact that will have filtering down to those that are in scope.
Yeah.
Okay, so is that the consultation document covered?
I think so. There's nothing else on my list that I wanted to go through, Tristan. So yeah, I'm happy to move on if there's any other topics you'd like to explore while I'm here.
No, please move on. Do you want to talk about GAD?
We can do. Yeah, happy to talk about GAD. Will your listeners know who GAD are, the government actual government? Okay.
They won't. I struggled to know myself sometimes.
Me too.
It's a very, very complex area that obviously we're not going to get into the weeds of, but I just think it would be helpful because, again, we do have lots of queries that come in, particularly with regards to those that fall in the ill health category, and the delays that can have. And I think it would be good to provide a bit of an explanation as to what's happening behind the scenes.
Yeah, no problem at all. So in terms of Matthews 2, I think it's acknowledged that Matthews 2 is much more complicated than Matthews 1. And because of that, the calculator that GAD have produced, so GAD are the Government Actuaries Department, they're an actuarial firm who the government employ to do all of their actuarial business. So you'll know about retirement reduction factors, commutation factors, etc. It's the boffins really at GAD that come up with all of these formulas. They've got fabulous brains there, too intelligent for myself. So GAD have been supporting the sector on Matthews since Matthews 1, and GAD were the organisation that put together the calculator. So the calculator is what FRAs use to come up with the cost that Matthews is going to be for individuals. So there's a lot of things that are built into the calculator, lots of formulas, interest calculations, etc. And the premise is you put in some information. As long as that information is correct, it will then give you a correct outcome. Now, Matthews 2, much more complicated than Matthews 1 for a variety of reasons, but mainly because some people have taken up benefits in Matthews 1 and they're now just due a top-up of benefits, or they're due different benefits because of Matthews 2. Which means that the calculator that GAD have provided is also more complicated than the first calculator. So my understanding is that the calculator that FRAs currently have works in around about 95 to 97% of circumstances. There are some circumstances that the calculator just will not work for because they are too complicated. And it was decided at the time that it wasn't worthwhile GAD investing their time and energy in developing a more complex version of the calculator. Instead, these complex cases that fall outside of the calculator use would be given a direct referral to GAD. So that's it really, in a nutshell. We know that 95 to 97% of cases can go through the calculator, and that will be the FRA's responsibility. But there are some cases that have to be referred to GAD. I think the message that I'm getting back from some, and this isn't for all, this is for some people, so some FRSs are coming back to me and saying, we've sent cases to GAD and we're getting regular requests coming in from members wanting updates, etc. But GAD aren't really telling us anything. So I think that this is a little bit of a frustration right now. I'll pause at that point, Tristan, just to see if you've got any comments on that.
No, I your knowledge of GAD and how that all works, I'm not going to go on that area. But I thought it was important to touch on it because there are certainly individuals out there who I know will be listening to this podcast, watching the YouTube channel, who fit in that category. I know it's a smaller element, but I thought it was important to cover that, as I think it's important to cover as much as we possibly can on this.
Definitely. And what I would say as well about GAD is we are working really closely with them to make sure that they are prioritising the right levels of cases, making sure that individuals who are wanting to leave if they're currently employed or are suffering financial hardship or something like that, that there is an escalation route that GAD can prioritise their cases. So that work is ongoing. And we're also working with MHCLG on that piece as well.
Okay, that's really helpful to know because I wasn't aware of that. So we can see whether we've got any situations that fall into that category. So that's really helpful. That's fantastic. There are other queries that we have on a regular basis that I know we can't go into any detail about yet. Mm-hmm. But do you want to touch on the fact that we hopefully will be doing another pod in the future that will cover compensation?
Yes, yeah, happy to do that. So When we talk about compensation in respect of the Matthews remedy, what we're talking about there specifically is individuals that have who have been put into a disadvantageous tax position because of Matthews and the passage of time that the Matthews remedy has taken. So I'll give you an example. We know that individuals now are receiving huge backdated lump sums of pension. And we know that current HMRC regulations does not allow an individual to go back to the previous tax years and spread their pension payments. Instead, people are receiving tens of thousands of pounds in arrears in one tax year, which is pushing them into a higher tax bracket. Now, we know that if Matthews had been paid at the time and, right from the point that it was due, we know that those individuals would not have had that level of tax to pay. So we're working very closely at the moment with MHCLG to come up with a compensation framework that will allow individuals to go to their former fire authority and say, you have put me into a disadvantageous tax position because of Matthews, and this is how much extra I have had to pay in tax. And the scheme manager at the FRS will have a direction from MHCLG which allows them to give them compensation to the individual and basically put their tax position right. We can't do this through HMRC. We know that HMRC's channels don't allow that. So instead, there is going to be a separate compensation mechanism that's created.
So I thought that was really, really important that you can touch on that. I know we're somewhat limited as to what we can say because, talks are in their infancy and there's a lot more to discuss and be worked out. But hopefully that will give those out there who are in that situation some hope and confirmation that you're not being ignored. Mm-hmm. We know that there's a problem. We know the breadth and the depth of the problem, but the relevant agencies and organisations are trying to come up with a workable solution to ensure that nobody is being financially penalised due to circumstances outside of their control. Would that be fair?
Absolutely, yes. In terms of timescales, I'm hoping to get something over the line this side of summer, but that is really out of our control at the moment. It's the government departments. As you can probably imagine, the compensation framework is going to cost a considerable amount of money. It's quite eye-watering, the sums that are involved. So there are several government departments that need to sign off on this. But really, it's just that reassurance that work is ongoing behind the scenes with us. We're keeping yourselves at the FRSA up to date with everything. And as soon as we know more about compensation, we will be looking to put together some guidance for members on how they put together their application. We can work with yourselves as well, Tristan, on making sure that guidance hits at the right level. We don't want it to be too technical. We don't want it to be too onerous. So yeah, we will certainly work with yourselves. And then in terms of, coming back here again, going through that guidance, then I'd be more than willing to do that if that's what people that dial into these podcasts would like.
I will definitely hold you to that. And I've no doubt there will be lots of people out there who will be very much looking forward to a future pod that covers that particular area, because there are lots and lots of people affected. And as you said, the cost will be astronomical.
Yes, it will.
Fabulous. So that's just to confirm that all of the relevant points are on the radar of the LGA, of your team, of the FRSA and other organisations out there. And we are doing our utmost to ensure that the appropriate level of service in terms of a pension receives the relevant in-scope individuals in a timely, correct and fair manner. Is there anything else you wanted to cover why I've got the font of all knowledge in terms of fire pensions on the pod.
There's definitely nothing from me, Tristan.
Okay. Claire, I cannot thank you enough, because if you weren't there and your team weren't there, I don't know how this information would be disseminated. I don't know how the support for fire and rescue authorities and unions would be facilitated. So thank you for being there, and your team. Thanks for coming on for the second time. I'm sure it's going to be another popular podcast. And we very, very much look forward to having you back and provide us with another update on Matthews 2, Matthews 2B, whatever it's going to be called, because it's extremely valuable.
Thank you for having me.
No problem. Thanks very much for listening. Don't forget to subscribe to the podcast and subscribe to our YouTube channel. So from myself, Tristan Ashby, and Claire, thank you very much for listening. Take care, and I'll see you at the next one.